Hi there, I'm Jim Fletcher, an estate planning attorney right here in Georgia. Today we're going to break down what the legal term per Stirpes really means and why it could have a big impact on how your assets are distributed after you're gone. Before we get started, take a second to subscribe to the channel. We post videos almost every week, and be sure to like the video. Every like helps us reach more people who want to protect their families and plan wisely. I'm the author of Estate Planning for Georgia Families, and I'm honored to be recognized as one of the top attorneys here in Georgia. Our firm was also named one of the top law firms. It's my mission to make estate planning understandable and accessible for everyone. So let's talk about the term per Stirpes, a phrase that shows up in wills and estate planning documents. In Latin, it means by roots or by branches, and it describes how a person's estate should be distributed if one of the named beneficiary dies before the person who wrote the will. They're called the testator. So what happens in that situation? Well, if a will has a per Stirpes clause and the beneficiary dies before the testator, then the beneficiary's descendants, usually their children, take the property. It keeps the inheritance in the family line, and it's fair, and it ensures that everything's split equally between children. There's another term, per capita, which means by the head. Then if a beneficiary dies before the testator, their share is not passed down to the kids. It's redistributed among the other living beneficiaries. So let's break that down. We have a couple, John and Jane. They have two kids, Michael and Michelle. Michael has two kids, Harper and Alfredo. Michelle has two, Aaron and Thomas. Let's say John and Jane write a will. 50% to Michael, 50% to Michelle per Stirpes. Well, if Michael dies, his share, his 50%, goes to his kids, Harper and Alfredo. They each get 25%. But what if John and Jane chose per capita instead? Well, if Michael dies before them, his kids get nothing. Michelle inherits the entire estate, 100%. So you can see the real difference between per Stirpes and per capita. In this example, we didn't even mention in-laws. That's because they don't receive anything from the estate. They're not direct descendants. They're not part of the distribution under either method. So it's not a problem. Using per Stirpes in your estate plan is a smart way to automatically plan for the unexpected, like a beneficiary dying before you do. It helps avoid rewriting your will every time something changes in your family. Makes probate easier, helps reduce potential conflicts over asset distribution. Well, that's all we've got for today. Hey, if you've been watching my videos, you know my goal is simple. I want to help Georgia families plan smarter and sleep better at night. So to help with that, I've written a book. It's called Estate Planning for Georgia Families. And you'll find a link at FletcherEstatePlanning.com. I talk about wills and trust and powers of attorney and healthcare powers of attorney and ladybird deeds, a lot of things. So if you want to learn more about estate planning, you can get a copy of the book. You can call me at 404-409-5665. We can set up a free consultation, or you can go to FletcherEstatePlanning.com also to learn more. Thanks for watching. Please hit the like button before you go. It helps me reach more people who need this information. Well, until next time, I'm Jim Fletcher, and I help Georgia families plan for what matters most.